Good afternoon, everyone, and thank you for being here. We are going to get started with our CLE presentation for today. This presentation is being hosted by the Florida Bar's Standing Committee on Professionalism. My name is Katrina Brown. I'm a professional liability defense lawyer at Bush Ross in Tampa and a current member of the Standing Committee on Professionalism and the Education and Resources Group, along with a few other presenters we have for you today, who I will be introducing shortly. The topic of today's presentation is Perspectives on Professionalism from Your Office to Tallahassee. I am very pleased to introduce Florida Supreme Court Justice Meredith Sasso. As a presenter today, Justice Sasso is the 93rd Justice serving on the Florida Supreme Court. She was appointed in 2023. She previously served as Chief Judge on the 6th District Court of Appeal and as a judge on the 5th District Court of Appeal. I am also pleased to introduce retired Florida Supreme Court Justice Kenneth Bell. Justice Bell focuses his practice on civil appeals and trial support. He is a co-chair emeritus of Gunster's firm-wide appellate practice group. In addition to serving as appellate counsel, he is also called upon as an arbitrator in civil and appellate matters. Justice Bell is a former Florida Supreme Court justice serving from 2002 to 2008. And prior to serving on Florida's highest court, he was a circuit judge in Florida's first judicial circuit from 1991 to 2002. And next we have attorney and Professor Timothy Chinaris. Professor Chinaris is a professor emeritus of law with Belmont University College of Law in Nashville, Tennessee, where he taught courses in legal ethics, torts, insurance law, and other subjects. He is licensed to practice law in Florida, Alabama, Tennessee, and Texas. Professor Chinaris was the ethics director of the Florida Bar from 1989 to 1997, where he ran the popular ethics hotline service that answers more than 25,000 calls annually from bar members. He has chaired bar ethics and professionalism committees in Florida and other states and maintains the legal ethics website sunethics.com. Now in full-time law practice, Professor Chinaris represents lawyers and others in a wide variety of ethics matters and serves as an expert witness in professional liability cases. He is of counsel to the ethics law firm of Smith, Tozan, Daniel, and Davis, PA, also here in Tampa, and also a member of the Standing Committee of Professionalism. And rounding out the presenters today is attorney Kalinthia Dillard. Kalinthia serves as general counsel and deputy inspector general for the Palm Beach County Office of Inspector General. Previously, she clerked at the 4th District Court of Appeal and practiced civil litigation at private law firms and worked as a senior attorney for the School District of Palm Beach County, the 10th largest school district in the U.S. Kalinthia currently serves as president of the Forum Club of the Palm Beaches and as vice chair of the Florida Bar's Constitutional Judiciary Committee. Additionally, she serves on the Florida Bar's Grievance Committee 15D and the PBC Bar Association's Judicial Campaign Practices Commission. She is also a current member of the Standing Committee on Professionalism. Our moderator today is attorney Dora Kaufman. Dora is a shareholder at Liebler, Gonzalez, and Portuondo with its principal office in Miami. Her practice includes complex commercial litigation in federal and state courts, banking law, creditors' rights, debtor-creditor workouts, and bankruptcy proceedings. Dora presently serves on the Standing Committee on Professionalism and is the chair of the Education and Resources Working Group. She served as faculty at the June 2023 Professionalism Seminar at FIU Law School, among many other notable accomplishments. On behalf of the Education and Resources Working Group of the Bar Standing Committee on Professionalism, I again thank you for joining us today. You may pose questions throughout the presentation in the Q&A box, and we will get to as many questions as we can throughout today's presentation based on time restrictions. I will now turn the presentation over to Dora Kaufman.
Thank you so much, Katrina. Let's start, if that's okay with you, Justice Sasso. Recently, in an August 2024 opinion of the Florida Supreme Court, The court accepted almost all proposals, but it rejected the proposal to delete the references to zeal and zealous in the preamble to Chapter 4 of the rules regulating the Florida bar and in the comment to Rule 4-1.3. Would you be good enough to offer some background on that decision and the rationale supplied by the court in reaching its decision?
Sure, and thank you all for having me today. I appreciate the opportunity. So the proposal came to us by way of referral, as is typically the course, and the proposal had several amendments to Chapter 4 of the rules regulating the Florida bar, but in particular, there was this debate over the terms zeal, zealous advocacy. We hear about that a lot in the legal field. You hear about it, right out of law school. And you can look, you can Google Florida Bar News for kind of the background discussion on how that proposal came to be. But essentially, I think there was a sense in the bar that those words were being weaponized and that the words were being used kind of to shield otherwise unprofessional conduct. And a lawyer could say, I'm just being zealous. That's why I'm acting like a jerk right now in a hearing. And so the proposal came, but I think, as is typically the case, those words had a lot of meaning that was well played out in the case law, and that's touched on in the opinion. I'll just highlight one portion of the opinion and explaining why the court declined to adopt the amendments to remove zeal and zealous from the preamble and from the comment to Rule 4-1.3. The court noted that while those terms can be associated with negative and extremist behavior and character, just because those terms have been used by lawyers to justify unprofessional conduct does not mean that is the actual meaning of the words, as the court had made clear. And so there's two citations to opinions that clarify that the terms zeal and zealous are not an excuse for unprofessional conduct. There is a Florida Bar versus Schwartz opinion explaining that the requirement of providing zealous representation is not a sword to wield as an excuse to otherwise engage in misconduct. And the Norkin opinion explaining that zeal does not require antagonistic or acrimonious behavior. And so I think the court felt that it was equipped to continue to discern between conduct which warrants discipline and that which is just zealous advocacy, even maintaining those terms in the rules.
That's very helpful. Thank you, Justice Sasso. Turn to you, if that's okay, Justice Bell. You served for a sizable period of time as a justice on the Florida Supreme Court. What are some of your observations from your service as to attorney professionalism and attorney discipline over the years and even more recently?
Yes, and before being on the Supreme Court, I served, as was noted earlier, 12 years as a circuit judge. So I'm the old guy here on the panel. But back in 1996, the Florida Bar, there was a Commission on Professionalism or task force to discuss it. And they noted that at that time that lawyer professionalism was, in their words, were steep decline. And there's been a series of efforts since 1996 to try to address that, including in 2013 when they adopted the Code of Resolving Professional Complaints and did the professional expectation aspect of that, and the court became more active. So the court has been trying to respond to what is continued, in my view, to be a continuing decline in professionalism, as we would hope and expect it to be. And the court and the bar moved from a passive, let's educate, let's have ideals, let's have goals of professionalism, to now we're going to adopt expectations and we're going to enforce it, not only ethical violations, but professionalism violations, and adopt the local panels that will deal with mentoring. And so the court's doing all it can, but it's a deep cultural issue that we have that I think has been exacerbated by many things. And if you talk to trial judges particularly, and the adoption of Zoom hearings, it's amazing how the lack of collegiality, the lack of respect. I was talking to a trial judge yesterday, a senior, well-seasoned trial judge, and she's had attorneys appearing in hearings in the back of their car in Zoom hearings and don't have a tie on or for the guys or appropriately addressed, and then the antagonism and the lack of communication with each other. Back when I started practicing, you had hearings in a court, you would wait outside the judge's chamber and you would have discussions and often resolve disputes that you hadn't resolved otherwise. But now I think it's everybody's texting, everybody's on social media, everybody's not communicating as we used to. There used to be more mentoring. There used to be more, again, relationship. Even when I was on the Supreme Court, it got to the point, and I think it's better now, but everybody just communicated to each other by emails, even though you may be 2 offices away. And so I think all of that larger cultural thing has led to a loss of civility and respect. And we got to realize that we just represent the clients, but we first and foremost represent the justice system, and that it should be done in a very professional way. So the words are there. The problem is, how do you enforce it, or how do you amplify it so that we have a greater civility? So I think it's a large hurdle, but one we must maintain in order to maintain the respect and integrity of the system. So I think when I was on the court, we started to become more, the bar would come with a referee recommendation of, let's say, suspension or a lighter sanction, and we started increasing those sanctions back then. And I think that is really happening. Tim and other people can speak to that now, but I think the court is not only disciplining ethical violations, but also is when they amended more recently in 2023 to add communications to the expectations. The court's doing what it can to address it, but it's a continuing problem.
Leads me to turn the floor over to you, Professor Chinaris. I know in the chat room, thanks to Eve Alvarez of the Florida Bar, there is a listing of cases that you had compiled of where the Florida Supreme Court has increased, recommended, or sought discipline over the last 10 years, in some cases from nothing or practically nothing to disbarment. And I know we had briefly discussed that certain items, whether it's outward deceit or dishonesty, improper use of trust funds, failure to accept responsibility, and much more. But what are some of your since a sizable portion of your practice at this point is representing counsel in Florida Bar disciplinary proceedings, and based on your analysis, what have the trends been, and what are the circumstances where the Florida Supreme Court has in fact increased the penalty or discipline beyond what was sought?
Thank you. And I would like to say I agree with most of what Justice Bell said. I think a lot of the decline in professionalism is real, and it's based on, I guess, a lack of community that used to be felt. There are more lawyers now. I don't think that's the sole reason. I think it's a lot to do with how lawyers communicate and how people communicate. After all, lawyers are people first before they become lawyers, and so they have those habits. And I think accountability and community is very important. I think the cases show that the court is taking accountability quite seriously and often is willing to increase disciplinary penalties from what is recommended after the trial of the case. And there's various reasons for that. The court may find, in some cases, additional violations that the referee didn't find. Court may lean more heavily on the fact that prior discipline was very recent, that there's cumulative discipline. The court may read the record differently and come to different conclusions as to what the appropriate discipline is. But I think one thing that you see throughout is things that go to honesty, integrity, and affecting the ability of the profession to work the way it should are things that the court is going to focus on and often will adopt more serious penalties than those that are recommended. And it's no secret, the court's been saying this for a while, and in many of the decisions, they will reiterate that over time, the court's moving toward greater discipline, and I think maybe for the reasons we mentioned.
As someone, let me ask just a quick follow-up, Professor Chinaris, as someone who's represented attorneys in ethics and disciplinary matters, can you comment on how those actions, based on lack of professionalism, are viewed by your clients, by the respondent lawyers and their counsel?
Well, I think the surveys show that the bar takes surveys every other year. They show regularly that lack of professionalism is a concern among lawyers. I think most lawyers share that, and I think most lawyers are welcoming of things that will be able to stem that tide, greater discipline for lawyers who have serious professionalism issues. I think the other side of that is one that Justice Bell kind of alluded to, and that's the idea that we have disciplinary rules. And in order to discipline somebody for violating those, the rules have to give fair notice of the conduct that is considered inappropriate. And in the professionalism world, a lot of the professionalism is how we perceive things based on norms. And it's really hard to define that in a disciplinary rule. And so that's why I think the people on that are my clients that are concerned that they will be accused of crossing that line between zealous advocacy and something that's really a violation of the disciplinary rules. And I think the court's done a good job of sorting out those cases and drawing that line, because if you look at the cases that are often cited as unprofessionalism cases, they always tie the discipline to specific rule violations of the disciplinary rules. I think the concern on the part of lawyers is that maybe it's perceived that the bar itself is not as careful in making those distinctions before they charge somebody with an ethical violation that really is probably more appropriately handled by a professionalism panel than the disciplinary system.
Well, that's a nice segue into Kalinthia. Since you've chaired a professionalism panel, you've been very involved on the local professionalism panels. Can you explain the function of the panels, their process for addressing referrals of unprofessional conduct, and maybe provide some examples of where conduct is being referred and handled by professionalism panels versus conduct handled through the formal grievance process of a disciplinary investigation?
Thank you, Dora. I live in Palm Beach County, which is part of the 15th Judicial Circuit. So I'll tell you a little bit about how we've handled the LPP process here in our area. And as you've heard previously, the Florida Bar and the Florida Supreme Court have been concerned about the declining levels of professionalism for quite some time, going back to the 80s. And in the 90s, when the Florida Bar Board of Governors approved the ideals of goals of professionalism, which were more aspirational. And here in Palm Beach County, we've tried to tackle it on a local level. In 1997, our chief judge created local professionalism, the Professionalism Council. And then in 2013, when the Florida Supreme Court adopted the Code for Resolving Professionalism Complaints, our Professionalism Council was then reconstituted as our local professionalism panels. And that was handled through the Palm Beach County Bar Association's Professionalism Committee. I chaired that committee for 3 years in a row, which gave me an opportunity to chair our panels here locally for 3 years. And some of the types of issues that we would see in the era of COVID and Zoom, we had one attorney who said he forgot his camera was on and used some very profane language after he didn't get the result he wanted in a hearing. And he came in to the panel and said, well, I didn't realize my camera was on. The hearing, had concluded. And we had to remind him that, if you were in person at a hearing in the back of the courtroom, you would not, conduct yourself that way. So reiterating the fact that professional expectations are required regardless of whether you're on Zoom, on the telephone, whatever mode of communication that we're utilizing. We had people initially who were not familiar with or comfortable with Zoom, I'll say, not dressing appropriately, not appearing for hearings in appropriate settings. Someone was on their bed. Some of the complaints we received from judges were attorneys who appeared who were disorganized, unprepared, missed hearings. Come up from time to time. People utilizing facial expressions that are rude and disrespectful. Sometimes, you don't think about the way you look. Now we're more aware of it when we see ourselves on Zoom, but it's important to not only speak in a way that's respectful, but approach the court in a respectful manner. We've received complaints concerning that. Inappropriate comments to judges, to your opposing counsel, to the litigants in hearings, in either in-person communications or in written communications. And even prior to the most recent opinion of the Supreme Court, if something was repeated or egregious, we would refer those matters to the Florida Bar. We had a very good relationship referring matters that came to us to the Florida Bar and vice versa. When the Florida Bar determined that, maybe that was a complaint that was more appropriately handled through a local professionalism panel. So I don't necessarily think the type of matters that will go before the panels will change with the most recent changes. Perhaps some of the processes will change. I was fortunate enough to be able to participate in some of the statewide meetings that were conducted by the Special Committee for the Review of Professionalism in Florida, created under past President Michael Tanner. And we came together to discuss our respective processes and procedures throughout the state of Florida with the 20 circuits, effectiveness. Different circuits have different experiences handling these matters. There were some who had no complaints over the year. In Palm Beach County, we averaged, at least when I was chair, between 5 and 15 per year. So we had a very robust committee sharing some of the documents that we had created. We had concerns at the time regarding the lack of confidentiality, which has been addressed in the most recent opinion, and just trying to find some uniformity of best practices that fortunately, have been addressed with the most recent opinion. I did want to add, if you don't mind, quickly, and initially when I took on that role, we assumed that a lot of the complaints would be from or about younger attorneys. That was not my experience. We would have people come before the panel and that would say, this is something I've been doing for 30 years. And we would have to say, you're very fortunate that you haven't been referred to a panel or to the Florida Bar before now. But I think for the most part, people felt that it was a valuable opportunity to get some mentoring, even for more seasoned attorneys, and to talk through some of these expectations. Because I will tell you, I met a lot of people who were not even aware that there's a such thing as the creed of professionalism, which ends with, my word is my bond. So we encourage the attorneys in our circuit to review the standards every year or on a regular basis so that you have a reminder of what's expected, and don't assume that your conduct is always in alignment with what's considered to be professional conduct.
Well, thank you, Kalinthia. Appreciate your bringing us up to date on the recent meeting in November of this year as to the chairs or their designees for the local professionalism panels. Just for any in this audience who maybe are not familiar, could you briefly explain the process of these local professionalism panels for addressing a referral, how the referrals take place, and what occurs then for the professionalism panel to review and for decision making by the panel?
Right. Again, here in Palm Beach County, we've had a pretty robust process in place for a number of years. Recently, with our new administrative order, we've created an email where all complaints come in to the chair so that everybody on the committee, and we have 9 people that are appointed by our chief judge as part of the panel, where complaints come in, they are vetted and reviewed to see if it's something that's appropriately addressed by a professionalism panel or sent to the Florida bar or, close it out without further action. Then it's assigned and it's reviewed, and the attorney has an opportunity to come in and speak with the panel about the conduct. Again, it's informal. We tell people we can't provide, we don't discipline people. We don't force them to come. We hope that it's something that adds value to that attorney to hopefully prevent such conduct from happening again in the future. And some of the issues that we're now facing with the new order is this was discussed at the November 18th meeting, which I did attend. We had representation from our circuit. I'm no longer the chair, but I was there as a member of the Standing Committee on Professionalism. Before, we house all the information with the Palm Beach County Bar Association. We don't, do this process through the bar anymore. So there was questions about, who's going to house all these documents, over periods of time. There were concerns about more education. If you're part of the panel, you have to be educated on what the panel does. But for attorneys in general, letting them know that the panels exist and there is an opportunity for an informal process to deal with some of these professionalism concerns. So in Palm Beach County, we tend to put articles in our bar bulletin that goes out to our membership, reminding people that the panels exist and they are a resource for the legal community. Some of the other things that were discussed during that November 18th meeting included who should be able to make complaints. The Supreme Court order says any person. In our local order, it says a person who has a good faith basis to believe that, some unprofessional conduct took place. There was someone from another circuit who wondered if it should be narrower to say someone who has an interest in the outcome of the matter that's being discussed. Someone else asked, should there be a written standard for a code of conflict as far as who should serve on these panels? I don't know the answer to that question, but it was discussed. And judges have asked questions about them referring matters to local professionalism panels, meaning should it result in automatic disqualification? The second DCA actually issued an opinion a couple of years ago saying, no, it doesn't. But there may be circumstances where it may be appropriate. So I think, we're evolving. We're trying to address these professionalism issues. In our order, we provide for potential resolutions that includes mentoring, referral for, ethics training or professionalism training. Sometimes it may be just a letter saying, don't engage in that conduct ever again. And again, also reminding people to review the standards and the expectations so that they are aware of them, incorporate those issues into how they practice law.
Thank you, Kalinthia. A good question has come in from one of the participants who's on a Florida Bar Grievance Committee from a different circuit. And he's advised that his committee has seen a growing number of bar complaints based on misconduct on social media. And a recurring argument they hear is that their speech should be protected by the First Amendment and considered political speech. Let me ask one of the justices, whomever would like to respond, is this issue yet coming before the Florida Supreme Court to be addressed, or is it still pretty new, just misconduct on social media and Florida Bar disciplinary proceedings?
I can think of at least a few cases where, as is typical of the cases that make it to our court, there is, kind of a amalgamation of misconduct, some of which included social media posts, typically tied to representation of the client or directly to the legal system. And so I think, I can answer to the question to the extent, yes, I think it's an issue. I'll decline to provide my opinion on, the First Amendment issue. But I think, a common theme in the misconduct is that professional conduct is not limited to the courtroom, and actions that lawyers take outside of the courtroom and their personal lives can sometimes impact the discipline case as well.
Justice Bell, do you have any observations as to whether from your years as a Florida Supreme Court justice or since that time about unprofessional conduct on social media or general trends in more recent years, whether it's as to improper social media conduct or otherwise?
Yes, I'm actually involved in a case now. It's a large case out of Tampa. It's before the second DCA, but it was a long 8-week trial, a lot of emotions and a lot of involvement on YouTube and other social media aspects. And it was the first time that I had ever seen the activity of attorneys and their spouses in something, making comments and being involved in people who are following the trial, that you had some of the attorneys and some of their spouses, et cetera, talking about these matters on social media while the trial again was being conducted, which, you have some concerns of what impact that would have on a jury, even though the jurors are told to avoid those things. We know they don't always do that. So I have seen that recently. So I think it is a concern, and it's actually being addressed ethically, I think, as part of that process. But I do have 2 points that I'd like to share that I think would be helpful. That the professional expectations are long, and they're pretty detailed, and they're very, very good. But as hopefully everyone knows and has participated in the mandatory 2-hour professionalism expectation course in 2023, last year, the court required everybody have the 2 hours of professionalism, and the Henry Lattimore Center has produced a fantastic 2-hour program that I happen to watch. And in that, they have Brian Tannenbaum gives 10 points on maintaining professionalism that I thought were excellent. And it was almost like the 10 commandments to Jews and Christians that we may need to post. But I think it's a good distillation of what's required and much easier to grasp and think about. And so I actually typed them out and put them up to where I can see them when I might think about crossing the line because I get irritated or something. But also at the end of that program, Paul Lipton, who 50-year member of the bar, gave takeaways from a master's, and so there's professional advice from a seasoned attorney, and he gave 7 points that he took from a program that he had watched from the center from experienced attorneys and former justices and judges that I thought were excellent. So I think those are 2 things that I think we should all distill, write them out, copy them down, maybe review them, put them under the glass or your desk, and look at them every now and then. Add it to don't send an immediate email when you get irritated by somebody, sort of like that, just to calm you down and put you in the right space before you act. I thought those were excellent for everybody.
Back to you, Professor Chinaris. I know we've discussed some issues about the increasing participation by non-attorneys in the legal profession. And in fact, we've discussed a recent decision of November 27th, 2024, called Harris versus Virage Capital Management, where in connection with funding of tobacco-related, very substantial tobacco-related litigation, the funding firm ultimately sued, obtained a judgment, and was able to obtain an order allowing for the sheriff to levy upon the counsel's interest in the law firm, which obviously, under the rules, you can't assign or transfer your interests in a firm except to other qualified counsel. But what have been your observations as to participation of non-lawyers in the legal profession, and how that has affected professionalism in the practice?
Well, I think it's hard to look at this without looking at what's going on in other states and how that might affect Florida. Several other states, notably Utah and Arizona, and before that, the District of Columbia, have allowed non-lawyers to become owners or partners in law firms. They're not allowed to practice law directly as a result of that, but they are allowed to, in some cases, as in Arizona, perhaps even wholly own the law firm. Other states are considering similar proposals, like eliminating the long-standing prohibition against sharing legal fees with non-lawyers, against paying for case referrals to non-lawyers, and even allowing for limited licensure of non-lawyers to perform certain services, limited legal services directly to clients. Now, I will say it's pretty clear the Florida Bar and the Florida Supreme Court to this point have shown no interest in going down that road. But Florida lawyers don't operate in a vacuum, and they are facing increasing pressure from well-financed, non-lawyer owned entities, whether they are financing companies or non-lawyer owned law firms. And these entities can finance, as we saw in the case you mentioned, substantial advertising campaigns, multi-state advertising campaigns to bring in cases. They can provide intake services. They provide technology expertise. They offer turnkey, what they call back office support for law firms, and can even offer to finance purchase of law firms. So I think the next big challenge for the legal profession, in addition to all those that we've mentioned, is how the profession is going to respond to these events. Because regardless of whether you view more non-lawyer involvement as a good thing or a bad thing, and people have arguments on either side, I think it's pretty hard to argue that as this increases, it really can change how the profession operates, which is going to affect lawyer professionalism and what that means.
Bell, a bit earlier, you spoke about the fact that during your tenure on the Florida Supreme Court, the court began imposing stiffer punishments on disciplinary proceedings than those recommended by the Florida Bar. Was this based on the belief the court had been too lenient in the past, or that the bar was being too lenient in determining the recommendations that were being made, or both? And over the years since then, from your perspective, has the bar tended to make harsher recommendations than it did previously?
I'll let Tim probably answer that second question since he deals with it more directly, or Justice Sasso now. But I think the bar and the referees take their guidance on what a reasonable sanction should be from precedents from the Florida Supreme Court. So I think what we were trying to do when I was on the court is make it clear to the bar and referees and attorneys who are caught in these situations that the court is not going to be as lenient as the court may have been in the past. And so it's just as if you do criminal work, you get to know the judge and what sentences are likely to that. I think the court was sending a signal to the bar and to the referees, et cetera, that you need to be a little more harsh or more serious about the sanctions involved. So I think that's really where it came from.
Well, Professor Chinaris, since your name was mentioned,
Thank you.
From your perspective in representing clients and defending it from the disciplinary proceedings, has the bar tended to make harsher recommendations recently than it did in the past?
I think as a generalization, I think you would say yes. Justice Bell's right. If you go back and look at disciplinary cases from 30 or 40 years ago and see what the sanctions were then and compare them to today, people that do this kind of work sort of just smile and laugh and say, wow, they certainly came out good on that one, because you're not going to see that today. And I think there's a lot of reasons for that, and a lot of them are good ones. But when the bar takes its cue from precedent, takes its cue from what the court does and what the court has said they take seriously, that puts the bar in a position to take a harder line at the beginning. And so it can make some of these cases more difficult to resolve early on. In the old days, when you could work something out, the bar knows now that they have a little more clout behind them in terms of precedent.
Based on your role for an appreciable number of years on local professionalism panels and the recent meeting you attended, what is your sense, or what has been observed by the 15th Judicial Circuit and other circuits from the recent meeting or otherwise as to the types of matters that are being increasingly referred to the different local professionalism panels?
As far as the types of matters, a lot of times it's more about how people comport themselves in writing. I think somebody mentioned earlier, don't send an email without giving yourself an opportunity to cool down. It's actually surprising some of the types of things that people are willing to put in writing. From time to time, it's referred to the professionalism panel, but people are attaching some of these emails to motions. And we found that a lot of our judges, want attorneys to resolve it. But we tell people, if you don't want that information to be in a court file, don't put it in writing. So I think constant reminders to people about all communications, not only what happens in person, but also through emails or, people nowadays are using other communications such as text messaging and things like that. But be very mindful and very careful about what's put in writing. And the expectation is that, you uphold yourself to the same standards that you would otherwise.
Dr. Chinaris, let me ask you, I don't know if you've come across this in your practice, in your defense practice, but are you able to address whether it's ethics opinions or practical observations to give direction to counsel on, for instance, how to respond to a negative online review or posting without running afoul and having a disciplinary referral?
Well, I think there are a lot of resources out there that people can go to provide that. The bar does a good job of publishing ethics opinions. And in fact, there is not only an ethics opinion, but now a rule dealing with responding to negative online complaints. And I think a lot of people are aware of that. I think one of the greatest things the bar does for its members is the ethics hotline service, where you can contact the bar. They have staff of lawyers who are well-trained and very knowledgeable in the resources, and they can point you to things that can answer many of your questions. And a lot of times, even if they don't have an answer for you, they can tell you whether there is authority out there on this in Florida or another state, at least give you something to go by. And I think it's a great service that the bar offers. And a lot of people take advantage of it. They get about 30,000 calls a year.
And Professor Chinaris, we know you were in fact the director of the ethics section of the Florida Bar and ran the hotline for many years. Kalinthia, for those in our audience who may not be very familiar with the new professionalism rules as outlined in the Florida Supreme Court's administrative order that was issued in July of 2023. Are you able to give an overview of those rules?
I think we've mentioned some of the changes previously. One of those matters that was discussed was confidentiality. That was one of the concerns that LPPs had prior to that order being issued. It also has a new procedure as far as who appoints the committee. The chief judge in our circuit appoints 9 members. The order from the Supreme Court doesn't specify a number, I don't believe, but we said 9 members. It does allow for 3-year terms. Previously, we did not have terms. It was just whoever was on the professionalism committee for the 15th Judicial Circuit. Now we have 3-year terms. So we let people know who are interested in serving. It is a commitment. And you have to be prepared and willing to do that. There is also information in there about, we discussed the new requirements for the 2-year, the 2-year CLE. Which automatically went into effect immediately, I think, except for those who had less than 3 months remaining in their reporting cycle. So we have to do the 2-year CLE for every reporting cycle. I've been told that, we have the current CLE, but they're working on the next one so that we don't have to review the same one for the next period of time. The mandatory meetings of the LPP chairs is an additional reporting requirement. So the Florida Bar News recently had a write-up with a report from that meeting. So I think it's a lot of valuable information that's being shared across the state to make that process more uniform, which is part of the objective when the special committee was established. We're still trying to, work out some of the kinks, but I think the ability to meet on a regular basis to discuss what things are working well in other circuits will, again, allow for that consistency across the state.
And in fact, I believe you're referring to the November 20th Florida Bar write-up. We're discussing, without naming, in part, the article references that without naming respondents, the report for the period December of 2023 to June 2024 cited behavior ranging from being rude to a JA to soliciting clients at a local jail. As some of the matters that had been referred to panels. What is your sense, Kalinthia, of when a matter gets escalated from your panel in the 15th Judicial Circuit for more formal investigation? Is it based on severity, on whether it's far more than an isolated instance? What other factors are involved in that decision?
Right. And I think the court has kind of given us guidance. Those things are relatively minor one-offs or more appropriately handled through the professionalism panels. When you have people who engage in repetitive conduct, those would be referred to the Florida Bar. We've had times when we've given the person an opportunity to come in and speak to us, and they've declined. And it was something that needed to be addressed. So we've referred those matters to the Florida Bar because it was, borderline, but it was something that we felt was important that needed to be addressed. The Florida Bar can compel people to show up, whereas we can't. So we've referred those types of matters. So again, when it's something that's pretty egregious or something, we had one individual that I can think of, we received 4 different, complaints about that person, their lack of professionalism. So that was something that we felt was appropriately sent to the Florida Bar.
On the floor a little bit. To you, Justice Sasso, I'll start with you, from your service, your continued service as a Florida Supreme Court Justice, if you could comment on your observations as to the expectations for attorney professionalism.
Yeah, I think, in terms of the disciplinary cases that I see, my impression, I haven't ever done an empirical study, but my impression is that the majority of cases make it to our court because of a commission rather than omission. So it's typically people who are actively mishandling clients, taking advantage of vulnerable clients, mishandling money, that sort of thing. But I think that there are a smaller percentage, and plenty of them, of cases where attorneys are just not doing their job. Somebody mentioned earlier that, I think it was you, Kalinthia, the difference between younger lawyers and more practiced lawyers. I've noticed what I perceive as a trend in younger lawyers who cannot keep up with the amount of clients they've taken on, solo practitioners who've bitten off more than they can chew, and that's typically where you see the omissions. And so I think in terms of standards for professionalism, treating every client that you have professionally and your interactions with opposing counsel professionally, but also ensuring that holistically you're equipped enough to handle the life, liberty, and property of the clients that you've undertook to protect.
I thank you for that. Justice,
Dora, can I add something?
of course.
I think part of that, Justice Sasso, if I could just kind of piggyback on that, and encouraging attorneys to manage expectations, when they take on clients, because a lot of times, when you have that lack of communication, because for the client, this is the most important issue that they're facing. For the attorney, you have a lot of clients. So, if you manage those expectations, if you talk to them on the front end and let them know, what to respect or what to expect from the relationship as far as how often you'll communicate or how quickly you'll respond to emails and phone calls and things of that nature. We felt that was something that was worth writing about in our bar bulletin I mentioned earlier, because that's something that's not necessarily in isolated cases, but something that all attorneys in our circuit could benefit from.
Justice Bell, what have been your observations, having served as a Florida Supreme Court justice and since that time, as to the expectations for attorney professionalism? And do you have any general additional practice pointers to offer to this audience?
No, again, I think my reference to those two aspects from that mandatory program and typing them out and putting them before you would be very, very helpful to do that. And I come from a tradition and family. My dad was very clear that if you don't have something good to say about somebody, don't say it. And I think if we, again, I mentioned earlier the culture we live in right now, it's everybody's got an opinion, they're free to express it, they're willing to express it, and it doesn't matter if it denigrates another person or not. And we have to get away from that, just for pure humanity and sanity.
And Professor Chinaris, since besides your service for many years, chairing the ethics hotline and as the director with the ethics section of the Florida Bar since then, based on your practice in defending these disciplinary cases, do you have any general suggestions to offer as to attorney professionalism that may lessen those instances or just would be helpful?
Well, I think things that are mentioned, have been mentioned, are all great suggestions. The thing that comes to mind for me is something I often suggest to people, and it first came to mind when I was answering questions on the ethics hotline. And people have a hard time being objective about themselves, and I think there are very few exceptions to that. And somebody will ask you a question when it's their own conduct involved, and they could talk themselves into pretty much anything, and that's how they end up in trouble a lot of times. So I often suggest, well, if somebody came into you and presented this to you, what would you say to them? Most of the time you would tell them, run away from that. Don't get involved. Don't do that. But when it's yourself, not the same thing. So it's good to seek out the advice of somebody that's a little more experienced or at least disinterested from the standpoint of being willing to tell you the truth. And that'll keep you out of trouble a lot of times.
Well, since we're approaching the close of our program today, I wanted to thank Justice Sasso, Justice Bell, Professor Brown, Kalinthia Dillard. I want to thank each of you and for serving as our panelists, and Katrina Brown and Judge Goodman and our working group for all of your assistance on the program, for all those who attended the CLE. So the course number is 8863. It's considered an intermediate course with one CLE general and also one CLE for professionalism for self-reporting purposes. I also want to give a special note of gratitude to the Florida Bar staff who've done a tremendous job with this program, to Rebecca Bandy, to Katie Jones, and to Eve Alvarez, for without them, this program wouldn't be possible. And to all our participants, some great questions, and we appreciate the opportunity to spend lunch hour discussing these important issues. I hope everyone has a wonderful day, and again, thank you.
Thank you.
Thank you.